Welcome. My name is Michael Pratt. I've been here at Boston University for about 16 years. My colleague Ken Zwicker is a patent attorney who just joined us a couple of weeks ago, but has got his PhD from BU some years ago and has been a practicing patent attorney for a long time. Neither of us can give anyone advice, specific legal advice about your patent questions. We're here to just kind of hopefully educate or share experiences, but don't rely upon us for any kind of advice about a specific instance because we're not qualified to, and we don't represent you, right? That's my qualifier. Today, I was asked to kind of give a very introductory talk to intellectual property. So the slides I put together are pretty fundamental. And that can be boring to some because you've got specific questions in mind. So I'd much rather make sure your questions are answered right away. So there were some posted online prior when you registered. And I'm just going to try to answer those real quick. And then as we get into the slides, I can bring out more things about those questions. But I think it's always nice to get your questions answered first instead of just waiting to the last slide. And these were given to me in no particular order. So I'll read them and then go through them. One was, what is the best way to keep up with trends in the patent law field? So, gosh, there's probably a number of ways to do this, and it depends upon your perspective. We rely upon a lot of online resources. So, for example, there's a gentleman who blogs about patent law all the time. His name is Dennis Crouch. Patently O is the blog. And when this, for example, there are Supreme Court decisions before the Supreme Court now, and he'll blog on those and he'll blog on the progress of those. And he gives a pretty legal yet understandable explanation for each of the issues. So it helps you get a sense of it. So it's Dennis Crouch, C-R-O-U-C-H, Patently O. I've got no connection to him. We just read the blog. There are organizations that you can connect with. There's the Boston Patent Law Association, and they put on, I don't know, maybe 12, 15 seminars in the Boston area a year by patent attorneys in the community dealing with different legal issues all around copyright, trademark, patents, all the different topics, licensing and all different topics. There are other associations like the Association of University Technology Managers, the Licensing Executive Society. Each of those organizations put out small, somewhat understandable publications around, again, different patent law changes and things like that. It wasn't normal that the Supreme Court would rule on patent cases, but over these last 5 years, they've lined up a number of them, and this has been a changing time. I can give more resources. Those are some that come to mind right away. The second question was how to discuss very nascent stealth technologies with experts in the field. For example, getting advice without worrying the idea will be stolen. Okay, this is a tricky question. And I always describe this as risk and reward. So you got to that's a balanced equation you have to consider yourself. When we're dealing with a new technology we haven't filed a patent on yet, assuming it's a patentable technology, yet we want to kind of get a sense from the field about, is this idea important or whatnot, we can have lots of conversations without saying what the idea is. So for example, if you had a new shoe technology and it made the shoe springier, whatever, some feature about the shoe, we don't have to talk about how we made it springier or what materials we used or any of that. We could just ask the shoe people, is a springy shoe important to you? How important is that feature to you without describing what the invention is? And sometimes you can get a sense from that other party of how important the problem is that you're trying to solve, that your invention is trying to solve, without even talking about how you solved it. And usually the secret part of the invention is how you solved it. Now sometimes there's sensitivities. If you're a large company and you're asking lots of questions about a particular area, you're kind of showing your cards. Wow, that big company must be interested in springy shoes. Okay? But if you're an individual or a small company, you're not much of a market threat yet. By asking a few probing questions, you don't really represent a threat unless there's 100 of you out there asking about the same thing, and then the big company says, wow, lots of people must be asking about springy shoes, so there's a trend in this marketplace. So in summary, we try to talk about the results of your invention and what the impact will be in the marketplace without talking about the invention itself if we're operating in a non-confidential sort of get to know you type of environment. And obviously there's different, with this risk-reward equation, the more risk you take, hopefully there's some resonant reward. So, if the venture capitalist or the person working for the big company, coaches your kid's soccer team, maybe there's a lower likelihood that if you tell them about your idea, they're going to turn around and steal it from you because they're going to have to face you every Saturday on the soccer field, right? But if it's someone you don't know at all or have no connection with, if they live far away, or if they're operating in a different country that has different business policies, that presents more risk, and you might want to be more protective in those environments. So you kind of have to hedge your bets a little bit and decide how much am I going to share in hopes that I get something back. If it's not a reciprocal relationship, they don't share things back, you kind of know to roll up the tent right away and roll back. But the next step over having a trusting relationship is to get pieces of paper in place, which are only good as the trusting relationship. But confidentiality agreements, and then those come in different forms. Then you can go higher and higher to secrecy agreements, and you can kind of make them more intense as you need to, or sign agreements where they'll pay you money to be able to see what's behind the wall. I don't know if I answered that completely, but that's a little bit of an answer. The next question I do not have an answer to. It was how to deal with parked domain registration that overlaps with ours. And this is the whole cybersquatting kind of field. I've not had direct experience with this, nor has Ken, so we're really not qualified to answer that question. I'm sorry. I could Google it for you, but that doesn't really do you much benefit. So I apologize, I don't know the answer to that question. Next question was, I'm interested in learning the basic process by which an idea turns into a legally owned intellectual property. Here I'm going to defer to the slides, because we go through those basic process, and it would take the whole presentation to talk about it, so I'll do it that way. The next was a broad question, discuss BU's approach to commercialization and its patented technologies. And this is difficult to answer, again, in a quick question, because what is BU? BU is a compilation of lots of people, right? So how one person commercializes their technology will be lots different than how another person commercializes technology. And we deal in lots of different fields. So there's no, like a company might have a strategy around how something gets commercialized. We have strategy around processes, but not around each individual commercialization story. Those are individual. There's some general approaches to it, but like I said, it depends on the market domain, depends on the person, depends on the technology. And we can go through some of those examples. I didn't really talk about commercialization in these slides. I talked more about just what is intellectual property. I have other presentations on that if we want to talk about that. So that's a weak answer to that question. But I can talk about how we patent technologies here. Next question is it possible to patent new techniques, methods that have been developed here rather than physical instruments or objects? So the answer to the question is yes and no. You can patent new methods. Methods, new ways of doing things, as long as they're new, useful, and not obvious, are patentable. Certain methods of doing things are not patentable. So a mathematical method of doing something, just the math itself, is not patentable. It's viewed as just math. Okay? A method of doing business used to be patentable, but is pretty much no longer patentable. If you just, you've got a new way of trading stocks or looking at a stock portfolio, those have gone under a lot of criticism. So the method of doing business has been put away, I guess, for the most part. So yes, you can patent methods, but certain methods are not patentable. And I'll get into more detail about that. When is it not a good idea to pursue copyright? Well, that's an interesting question, because as soon as you write something down, you've got copyright. So you're pursuing it because you wrote it down, right? I think the question might be, when do you go through the effort of registering your copyright, which is really cheap. It's $35, $40 with the USPTO. And the reason why you'd register something is, if I wrote a poem down right now on a piece of paper, I've got some inherent, that's the first expression of that, I've got some inherent rights, at least under US law. And if someone started to copy it, I could say, hey, stop copying it. That's my poem. I put a little C on that. You don't have to put the C anymore. However, if I was going to collect damages from that person, I couldn't say, now pay me $10 for every time you publish that poem, because my copyright wasn't registered. But if you register the copyright, and then someone infringes or copies it, then you can seek damages from that registration date forward. So if the question was pursuing copyright, meaning registering the copyright, that's the answer. If it meant just pursuing it in general, well, you sort of have it. The moment you write it down, you've got copyright protection under US law. So you've sort of pursued it. Now, pursuing a commercialization, that's a whole other story. Depends on what the copyright is and how you're going to commercialize. Then there was just words patent filing process. We'll talk about that a little bit. And then, can a service be patented? And that really relates to the method up above. If it's a method of doing business, pretty much no. If it's a service that involves some inventive steps, trying to think of an example. There could be examples of services that would be patented. Perhaps if it's a service for example, analyzing some data, where you're using some novel steps in the way you analyze that data. It's a little bit of a stretch, but perhaps you could come up with some sort of service patent around something like that. There's some downward pressure on software-based patents with this Alice decision with the Supreme Court. So it really depends on what the service is. But if it's a method of doing business, no. So those are the questions that were posted online. I'm sure you have other questions, but I should go through some of the slides to do it. And I think you said, Lena, that people watching online can tweet you, and you'll say, Mike, I got a question, and we'll address it. So for those of you out there in the world, if there are any, ask away. OK. So this is an introduction to intellectual property. First, we start with the US law. And most of my talk will be around US law, right? Because that's where we are, and that's what I'm most familiar with. It is part of our Constitution, right? So the Founding Fathers are giving authors and inventors a exclusive right to these ideas when they create them. And you can think of it in different forms. You know, the dictionary says a product of the intellectual that has commercial value, right? It's kind of a broad term. And there's all these different ways to think about intellectual property. There's inventions, innovations, original works, know-how. I'll talk about these in a little more detail. But there's formal ways to protect intellectual property under the law. And that's kind of what people think about, I think, when you think about intellectual property, these formal constructs that give you some legal rights that allow you to enforce your rights or trade your rights. And that's really what we talk about when we talk about intellectual property. And those are in the forms of patents, copyrights, trademarks, and trade secret. And I'll talk a little bit more detail about each of those. Funny cartoon for entertainment. You know, you have some fine ideas, but I'm afraid I already have a team working around the clock to make them mine, right? And that's a classic scenario. There's another cartoon we have that says, yeah, I have lots of good ideas, but I'm not going to tell you about them unless, you know, there's the right motivations that are in place. And that's an employer-employee kind of relationship as well. Another big important thing about intellectual property is who owns what. And since I work at an academic institution, I usually think of inventorship, authorship, ownership. When we publish papers, and there are lots of authors, you're including authors for lots of different reasons. They may not have actually written the paper, right? They might have contributed some experiment. They may not be an authorship under copyright law, but they're an author on your paper because they contributed something. So inventorship for patents is people who have made an inventive contribution to the claims. So you're going to look at the claim of the patent, whatever the real estate that you're claiming, and if you made an inventive contribution to that claim, you're an inventor. And it's incorrect to list too many inventors and incorrect to list too few. It should be a matter of fact and accurate. And the number one way you get your patent thrown out, if it's tested in the courts, the first thing they go after is inventorship, because it's usually an easy thing to find some angry person who thought they were an inventor. And they get them up on the stand and say, were you an inventor? Yes, I was an inventor. Inventorship's wrong. Case closed. Authorship is really tricky, right? Because this gets into copyright. And copyright's complex. So if you sit down and write some software, you know, you're the author. And if you're the only one who wrote that, you didn't go grab code from the internet, but you just wrote it, you are the author. If you're the author, you're the owner, okay? Unless you agree to assign your rights to somebody else, okay, through a contract or an employment contract. Same with inventorship. Under US law, if you're the inventor, you're the owner until you give your rights to somebody else through an employment contract or something else. Sometimes you have multiple inventors. Sometimes you have multiple authors on the software. And that's where the law gets a little bit more confusing, too. If you have multiple inventors, and let's assume there's no company that owns the invention, but rather the inventors themselves own it, the inventors have an equal and undivided ownership interest in that invention. And they don't need to account to one another. So I always give the example, if my brother and I bought a car, which I would never do with any of my brothers, if we bought a car together and then we sold it, let's say you sold it for $500, you'd think you'd give me $250 because we both owned this car. We had an undivided equal interest. But with a patent, if you don't have an agreement otherwise, you can operate under that patent and, let's say, license it to somebody else and collect money, and you have no obligation to pay the other inventor, even if they paid for all the patent costs. And there's no responsibility to account to one another. But you do have certain restrictions. So if you go to Europe, you can't license it to somebody else without the permission of the other inventors. But under US law, you have this sort of freedom. Authors, though, it's a different story. All the authors have to agree before you do one of these transactions. There has to be consensus among those authors. And there's an obligation to share some money. If something's licensed, there's an obligation to share it among those authors. So, and then ownership, of course, probably resides with your employer for the most part, because you usually sign that away. But many times you make inventions by yourself and not part of your employment arrangement. And you would then be the owner until you agreed to assign that to somebody else. So inventorship, authorship, ownership, three distinct concepts. OK, this is a little more drill down to the types of intellectual property, just to kind of give a little more color to it. So patents. Patents protect ideas. And some examples like composition of matter, method, design. Copyright protects the expression of those ideas, right? So the ideas in your head, you can have constructive reduction in practice, that's patentable. You can actually build it, that's patentable. When you express that idea in a tangible medium, that becomes copyright. So many times you'll have an idea, a method of doing something, that's embodied in the software. So you can get both patent protection and copyright protection. MaskWorks, I haven't dealt as much with these, but these, if you're making a semiconductor device, you need these photolithography masks, you can get some protection around the arrangement of those masks. Trademark. Trademark is, the Nike swoosh and things like that you see in the marketplace. It's really to avoid confusion in the marketplace. You want to make sure you're buying that product that has that certain quality around it, so they market a certain way, and you protect that trademark so people know that those are your products. There are also service marks. If you provide a certain service, you get service mark, trademark, different types of trademarks. Trade secret. People underestimate the value of trade secret, but it is very important. We don't deal with it as much at universities because we're an open environment. We publish things. We don't really deal in secrets per se. But for companies, it can be very important and critical, and they last a long time. So if you know cymbal technology, when you're drumming, you hit the cymbal. There's a company down in Connecticut that's held that in the family, that trade secret, for like 300 years. Maybe about 7 or 8 years ago, there was a fight in the family, so now it's in 2 companies, or the 2 brothers. But it actually immigrated into the United States, and they kept the trade secret within the family. So a trade secret can last a long time and give you some competitive edge in the marketplace if you choose to go that way. And then know-how. This is probably the biggest underestimated asset. If you don't know how to do it, you're lost, right? What works well at companies, a lot of times it's not the patent. It's just that they put together the right combination of people that just know how to build a product or make a good product. And that's valuable, right? And that, if you look at the value of companies, it's not always the brick and mortar, but it's this talent that they have and the people that know how to do things. And in fact, at academic universities, when we transfer knowledge, the piece of paper, the patent, yeah, it's got a certain legal right and a certain value. But if it's an early stage technology, we're in an enabling license, not a stick license where we're enforcing the rights, but rather an enabling license where we're building something new, that know-how is more valuable than the piece of patent. Later on, talking about a financial transaction, an issued claim, and someone's infringing, then it's a piece of paper and a legal issue, and the know-how is less of a concern because it's practiced in the marketplace. So it's timeliness around know-how. And then, of course, names have certain protections to some degree. We won't deal with that as much. But obviously, if these things aren't enforceable, they don't have value, so that's where the laws and whatnot come in. OK, so we're going to drill down now into patents a little bit to get in a little more detail. A patent gives an exclusive right, and it's a 20-year term from the day you file it. You might not get issued for 4, 5, 6 years afterwards, so it's kind of like 14 years after issuance, so you can think of it that way. It's not a right to practice, and this is a common misconception. A driver's license allows you to drive a car. A patent doesn't allow you to practice the idea. It just allows you to exclude other people from practicing the idea. And this is a concept that's lost on a lot of people. And I give a fictitious example all the time. I talk about fishing. And if you had a patent for fishing, which would like be a big circle in a Venn diagram, but someone else went and got a patent for fishing with a fish pole, even the person with the patent for fishing couldn't go fishing with a fish pole without a license to that patent, unless they wanted to just forget about it, right? Because no one's going to sue about that. And likewise, the person with the patent for fishing with a fish pole, they can't go fishing with a fish pole without the license to the broad patent that's for fishing in general. So it's not a right to practice. It's only a right to exclude others. So what does it take to get a patent? New, useful, non-obvious. OK, those are the 3 criteria. So new, never described before. Useful is pretty easy. It doesn't matter if the use makes sense or not. Your umbrella's for your shoe or some crazy invention. That doesn't matter, just as long as you can show utility. Utility did become important, though, with gene patents because there was a question around genes. They naturally occur in your body, but then it was really the use around the genes or the function of those genes that really became more salient and more important in the marketplace. So that's where the discussion around use came up a lot. Non-obviousness is tricky. Anyone's welcome to try to define the word obvious. should be obvious, right? But it's a tricky thing. It's a subjective thing where you're working with this patent examiner. They're looking at art, and it could be even two disparate references. It could be A plus B, even though A plus B doesn't equal your idea. A has a little bit of your idea, B has a little bit of idea, so the examiner says, it would have been obvious to anyone skilled in the art that this idea would have come about. But if you think of the field of engineering, everything is a combination of things that existed already. So then obviously there's got to be room for novelty. And usually they look to overcome obviousness arguments. The obvious example is, well, how come no one did it before, right? But other arguments are if you can show unexpected results. For example, if the literature taught away from doing it, but you showed that the literature was wrong and you came across some result, that's a good argument to overcome obviousness. Or if you can show that, oh my gosh, everyone thought I'd get 10% more performance, but when I combine these in this particular way, I got this resonant effect, this 100% performance, right? Unexpected results help you overcome this obviousness argument. But it really is a subjective, and it really depends on your examiner. And many times the examiners are people who are recently out of college. They don't have a lot of experience. They're under certain measures and pressures under the patent office, and sometimes it just takes a little time to educate them, to understand what's different and new about your idea. And the ideas do have to be reduced to practice. It could be actual or constructive, but you have to show examples of how this works. In fact, it has to be described such that somebody skilled in the art can reproduce your invention without undue experimentation, right? Now, you can guess at it. If you get an idea in your head and you want to file a patent, you could do that. You can guess at how it might work. Your guess might be wrong, so therefore your patent might be under some scrutiny. But you're allowed to do that complete guesswork of how it might actually work when you reduce it to practice. It's better to have examples. It's better to have data. That makes the patent stronger. In a company, a lot of times, you can work on something internally for years, get lots of data, and then file a really strong patent. In the university setting, it's a little bit different because we publish a lot. So we always are struggle with this balance where the data package might not be 100% complete, but we try to file the type of patent we think the best we can get given the circumstances we're in. OK. So there's different types of patents. What I deal with mostly are utility patents. Novel composition matter, process methods, apparatus, article manufacturer. There are plant patents. We're not at ag school, so I deal less with those. And I don't think there's many ag people on the phone, on the internet, so I won't talk about that. There are design patents. We filed, I think, in my 16 years here, 1, maybe 2. Design patents are good, but they're sort of fleeting in a way because when you think of a design of a product, the way it looks, the way it feels, a certain design, it's really only useful if that's the design that you're going to go forward and commercialize. And at the university setting, a lot of times we're not dealing with those types of technologies. We're dealing with fundamental ideas that are some years away from commercialization. And it's usually the companies that come up with those final designs of how the product will look because they start to interact with the customers more. But if you did have something that was kind of more perfected and you really thought that particular design was the way to go, you can get a design patent. They're a little easier to obtain in a shorter time frame. OK, there are things you can't patent. Laws of nature, naturally occurring phenomena and compositions, abstract ideas and algorithms. It's kind of straightforward. It got a little confusing with this Mayo Prometheus Supreme Court decision when people were given a synthetic compound, and then there were changes in their biochemistry. A biomarker would go up or down depending upon their reaction to this synthetic compound. And the Supreme Court ruled that as a natural phenomena, that that's the body's natural way of reacting to that synthetic compound. And that kind of rubbed people, I think, a lot the wrong way around this natural phenomena thing. And that's why there's a lot of downward pressure on diagnostic patents right now because of that and other decisions. Public disclosure. So this is another thing that gets people all the time. They don't realize they made a public disclosure. If you sell a product, that's a public disclosure. Even if your idea is in there and it's kind of baked into that product somewhere, the assumption is that people will be able to pull that apart and see how it works, and it's a public disclosure. If you publish it, it's a public disclosure. Nowadays, abstracts come out online real fast. You didn't realize you put enabling stuff in that abstract. Boom, it's public disclosure. And that's used against you on the obviousness argument. So even though maybe you described half the idea in your abstract, not the whole idea, it's prior art and becomes used against you in that case. If you talk to your mother, it's a public disclosure unless she agrees it's confidential. So you've got to be careful just in those little conversations you have. Unless the two parties agree that it's confidential, it could be agreement verbally, but then it'll be a he said, she said type of environment. If you have a poster up at a conference, but it's only there for a couple hours or something, that can also be a public disclosure because someone could go by nowadays and take a picture with their iPhone, and it's a permanent display. If you give a poster presentation at a federal agency and it's a closed group of people, it still may be a public disclosure because it's at a government agency, even though it's the closed group of people around subject matter X. Government grants. When you file for a grant with the government, that grant, when it's awarded, becomes publicly available through the Freedom for Information Act. This is a gotcha, right? You applied for the grant, you went through the whole process, you got awarded, you're like, I got the grant. In there is described maybe the heart of your invention. You hadn't filed a patent yet, but you didn't realize that once it was granted, it's available to the public and becomes a public disclosure. And really, it's only important when your patent becomes important, but that's when you want it, right? But that's when they dig up the paperwork and they say, hey, you got this grant before you filed. It was in the public domain. Right. Library submissions obviously are a public disclosure. A lot of gotchas are library submissions in other countries and other languages. So you know that Soviet era Russian library that stores all these interesting physics journals. How the heck would you come across that? But that's still available to the public and viewed as a public disclosure. You can do some safe disclosing. You can file a patent first. That's an example of something. Confidentiality agreements. We talked a little bit about this when I asked the question earlier, answered the question earlier. Or you could talk about how it's done, not what it does. Well, you could talk about what it does, not how it works. There are international agreements in the patent system that I just want to make you aware of. So the patent system is a government system. So it's specific to governments in different countries. A patent in the US is not a patent in Japan, is not a patent somewhere else. There is no uniform patent system. People would like to have that, but there's not. But there are agreements among the countries. And one is the Paris Convention, and one is the Patent Cooperative Treaty. So you can file a patent in the United States, a provisional patent. Okay, you have then 1 year to file a full patent application, non-provisional application. Okay, but because of some of these treaties, because you filed in the U.S., it becomes a priority date, and you also have this 1 year to be able to file in France or in Germany or in Japan. The Patent Cooperative Treaty gives you yet another kind of convenience. You can take an application in one language, usually ours are in English, and you can file it at the PCT, and it becomes a holding place before you, because it's expensive to go into each geography. You've got to pay fees, you've got to do translations. But before you make that decision, you could file your provisional. That goes about a year, but you'd probably file sooner. And then you'd file your non-provisional, PCT application, and then you're sort of holding it for all these member countries. You're holding the right to be able to file in those different countries for another 18 months. So now you essentially got 2.5 years before you have to decide that expensive decision of going in all those different countries. And it is very expensive, and it's also additive. So once you file in those countries, they have annuities each year, so it sort of goes out exponentially once you decide to go internationally, right? And you could easily spend $300,000 in the lifetime of an international application, easily for one application. The PCT, though, doesn't cover all countries. So, for example, Taiwan is not part of the PCT, or Argentina, right? So if you have a certain technology that's specific to those geographies, you'd need to know beforehand. That's what a patent looks like. This one's on the wall out front and became very important for Boston University and was used in all light-emitting diodes. We use that as an example. The front page of the patent has lots of information, priority dates, when it was filed, who the inventors were, sometimes who the patent attorney was. This is valuable information. So you can find out, if you're trying to find out who at this company could I work with or talk to about this technology, I'm so interested in working with them, look to the patent literature, right? You get so frustrated talking to the front door all the time, or the business development people, or the gatekeepers. All the names of the company, all the inventors are listed right here in the patent application, right? And scientists are usually pretty friendly people. They're usually willing to talk to you when you call them on the phone. So right here, there's a database of all those people working right in your field. So if you find a bunch of patents that are kind of similar to yours or similar to your area, you got a list automatically of the people who might be interested in that idea if you want to talk to them about that. OK, claims. So your patent is comprised of different components. There's what we call the specification, which is all the words that sort of describe the enablement, give the background for the invention. And then there's the claims. And I'm just going to spend a few minutes on this because it's important. Your invention is what the claims are, what the claims describe. but your patent is the whole thing. And you may start out with one patent application with one set of claims, and as it goes through its process, you realize, oh, that other stuff I described in the patent application is important. You can as long as the application is still alive, you can reach patent specification and bring that out and draw new claims, okay, as you start to refine your idea or find out what's more important about that. So it's important to write a good specification so that you can really capture the full body of the idea. But the claims are what's important. I think when you think of physical property, it's helped to visualize it a little bit. If we lived in, for example, Texas, and I bought a nice piece of land, it's very two-dimensional, right? It's actually the boundaries of that land in a two-dimensional plane. And then later on, when the guy pulls up his truck onto my property with the big well and starts digging to do the fracking in my backyard 200 yards from my pool, I didn't buy the rights for the stuff underneath, right? Because my claim only covered that two-dimensional plane. In fact, when the UAVs start flying overhead and dropping pigeon stuff on me, right, I didn't claim that airspace because my title, my claim didn't claim that, right? So you have to be careful when you construct these claims that you're covering what you think you're covering, and be clear about that. And there's lots of examples. When that patent that I mentioned to you just earlier, when those claims were put to the test under the different patent suits that we had over the years, it really came down to two words. And one word is the word on, right? And that was debated by courts, and millions of dollars were spent on the word on. And I'll give an example. I'll see if I can do it in a way that the people watching online can see it. But oh, here, this tape dispenser, which happens to be here. Most of you might agree that that's on my hand. I don't know. Does anyone? yeah. Does anyone disagree that it's on my hand, right? And then the question really was, is the tape dispenser on my hand? Okay. Now, it depends on how you use the word on in the specification of the patent. Because the definition of the words, think about it, in a patent, you have to use today's words to describe tomorrow's ideas, right? So they allow for you to define words, common words. They allow you to define those in the specification so that you can avoid a confusion like this. So when you use the word on, you describe the word on, you make sure it covers this and it covers this so that the word on is used properly. And the other word was the word comprised, which is, over time, and patent people, they build up special meanings of words. And comprised is different than composed. In this particular case, there was a layer of material, and the word was comprised of gallium nitride. And that just means that gallium nitride was an essential component of that material. It didn't mean that the whole thing was gallium nitride. You could have all sorts of other stuff in there. But if we had used the word composed instead of comprised, it would have meant that that's gallium nitride. It's nothing else but. So the reason why we hire attorneys to write the applications is because you and I would, yeah, it's on. It's on. Any idiot would know it's on my hand, right? But the attorney says, no, I got to write this a certain way so that on means a certain thing. And we lose that subtlety sometimes when we're working with the attorneys, because when we read it, oh yeah, it's just on. I said it said on. It says on. But they did some tricks in there to kind of make sure that those words line up the right way. And it's the words that kill you in this business. And sometimes you think you got this broad claim, and then someone identifies a little scapegoat through this. But you used this word the wrong way, like the or something like that, some complicated word. Okay, obtaining a patent usually starts where you get the idea in your head, and then of course you write it down on a piece of paper. So you've already lost some of the idea because some of it's stuck in your head. When you write it down on paper, you give it to someone else, usually through an inventor disclosure at your company or at a university. Usually there's some sort of assessment around patentability to look for novelty and non-obviousness questions, because you want to try to eliminate the obvious things. And you pay an attorney. Then you, after some time, you'll file this utility application. You may file a provisional first, but you'll pay your attorney to file that application. When you file that full non-provisional application, that's the step where you spend the most money, because they're writing that full application. But under changes in the patent law, it's really more important to write a more complete provisional these days. So a lot more people are spending more time, more effort on the provisional stage, which presents a little more risk because you got to spend more money up front. But it's the better thing to do. It's the better practice. So then you wait some time. Right now at the USPTO, depending on what domain you're working in, once they get a hold of the application, it's probably 3 to 5 years before you get an issuance. Probably we get an average response time of 3 years by the time we actually file it in the USPTO, and they pick it up. And actually, they're supposed to get back to us in 14 months. That's what they're supposed to do. But it's not working that way. So then you get to this prosecution stage. So So you went through this process doing your prior art search, you file your application, it sits there at the patent office for a number of years, and then they finally pick it up. And you're basically debating with the patent office, and we call that prosecution. And you have these things called office actions, which is the volleys back and forth. So you have this initial office action. Sometimes they'll say, you know what, you got 6 inventions here, not one invention. And then they'll divide up the 6 and say, which one do you want? They call that a restriction requirement. Which one do you want us to focus on first? You still preserve the right to pursue the other 5, but you've got to pick one to start with. So that's called a restriction requirement. Not always the first office action is a restriction requirement, sometimes. You pay the lawyer to interpret this. And each time we do a volley, for us it costs us between $3,000 and $5,000 each time there's a volley, because the attorneys look at it, they interpret it. Sometimes they have to work with the inventors. They formulate a response, and then you do the process. So we file a response, pay your lawyer for that. You have a second office action, you pay your lawyer some more, response, the process continues. Sometimes you'll do an interview with the examiner. If they're really just not getting it, the inventor's saying, where did this person come from? They're just not understanding the words on the piece of paper. That's when you know a personal conversation goes a long way. And sometimes you'll go down to the patent office with your attorney, you'll meet the examiner, hi, how you doing? It's a public government facility, you can go in there and talk to them. And then you'll work it out, and sometimes they'll go, oh, I thought you meant on, not on. You know, sorry about that. And then they'll avoid the confusion, and you'll get through it. But of course, it costs money, because if you're going to fly down to DC with your attorney who's getting $700 an hour, you know, it's expensive. So you pay your lawyer a lot. And then there's a final office action, but it's never final, because if it's the final office action, you can keep the process going by filing a request for continued examination, which basically puts you back at the beginning. You start the process over again. Or you can file an appeal and say, this person's a moron. I need other people at the patent office to see that this person was a moron. But you know, that's a little more expensive process, a little more timely. If we were a big company, we might pursue that path. We tend to file requests for continuing examinations and start the process over again with a slightly different tact on the convincing strategy. So when you get a notice of allowance, it says for these particular claims, you've come to some sort of conclusion. Your debate's gone back and forth, and you've whittled it down to a certain set of claims. And they say, we will allow these claims. And you pay the USPTO a fee, an issue fee. But before you pay the issue fee, if you want to file what they call a divisional application or a continuation to claim some of that other subject matter that didn't end up in your claim, maybe you'll go back to the first claim because you want to start the debate again, you need to file that before you pay that issue fee. Once you pay the issue fee, and that case is closed, it's no longer active, it's just an issued patent. You can't reach back into that well of the specification. So sometimes people will file a continuation only to keep the case alive such that they can reach back into that patent well if they need to later on. And that's what happened with our famous LED patent. There were some claims that our licensee wanted to hold on to, so they filed continuations. And later, much later in the life of the patent, maybe in, I don't know, 2009 timeframe, the patent was filed in 1991, they got issuance around some broader claims. Now, the life of that were not too much. They were just going to last to 2014. But those broader claims weren't used in our suits, but they were still helpful to throw some muscle around that. OK, like I said, you can file the divisional as long as you do it before the fee. That's why I said it first. Pay a lawyer to do that. Apparent issues. The foreign prosecution is going on in parallel. We say 2 to 3 years delayed because if you file directly in the US and you file at PCT, you get that 18 months right there. And then there's some different delays in the different geographies. Some countries go faster than others. And then, of course, you're paying a lot for overseas because you're paying for translations. You're paying for a foreign associate to do all this language, and they have to translate everything back because you want to know what's going on with your case. I can't read Chinese, so I can't interpret the applications. So it's expensive to go overseas. And for some markets, it doesn't make sense for your products. OK. Provisional patents are available in the US. It's nice because it doesn't count across your 20 years of patent life. You can file as provisional. In the past, we used to do lots of slapdash provisionals. You know, you get a manuscript, you throw a cover sheet on it, you send it in, you pay $100 at the patent office, voila. But now there's a huge amount of scrutiny around the construct of those cases. So there's a higher bar now where people are filing more complete provisionals. So people now will file a full application up front as the provisional, get that extra year time frame, and then not spend as much time at what we call the non-provisional stage or conversion stage. This gives you kind of a rough idea. It says university approach, but this could just be a general approach. And it doesn't have to be this way. But if you get a disclosure at the beginning of the process, and maybe within 3 months or so you go through a patentability opinion, it might cost you $600,000, $1,500. You could spend as much as you want with attorney. You could spend $5,000, $10,000, depending on how detailed a question you want to do on the patentability opinion. If you file a more complete provisional, not a full one, it could be around $7,000 or so. Then that starts your clock ticking. That's the number 12 there for 12 months. We typically file the PCT application, although we should go directly in the US in some cases, and we may do that. But we'll file the PCT because we're usually looking for a licensee, and our ideas are usually a little bit earlier. So it buys us a little more time. And the PCT publishes 18 months after the original filing date, so it becomes part of the public domain. A US application also publishes 18 months after the original publication date. So that's tricky sometimes for faculty members because sometimes their patent, if they're really trying to work on an area and they want to file a patent, but they're not ready to publish it because their work's not complete, the data's not complete, sometimes the patent will publish before their publications do, and that can be a little tricky sometimes because maybe the patent was more constructive reduction of practice, whereas their data and their papers is different. So you got to be careful about those issues as well. And then after you file the PCT, you have this 18-month period to decide whether or not you go into all these different countries. And just to give you rough ideas, again, with today's exchange rates, with today's circumstances, if you went into Europe, when you entered Europe, it would cost about $10,000. Okay? If you went to Japan, it would cost you around $15,000, $17,000, depending upon how many words are in your application, how complex your application is. If you went to China, a few years ago, it was around $10,000. Now it's probably around $5,000 or $6,000 because the exchange rate's a little better, but it kind of goes up and down. And also, China is becoming more popular for patent rights, whereas in the past it wasn't. India, you might spend around $10,000. As you get into like the BRICS, Brazil and Russia, you're dealing with translation issues, so you're probably around $7,000 or $10,000. But that's just to enter. And then once you enter, you pay an annuity each year in each of these countries. And then when you're doing prosecution, all those volleys that are $3,000 to $5,000 each, now you're defending yourself in 4 or 5 geographies. It starts to add up real fast. So we had one case about a couple years ago. We went into 20, maybe it was 16 geographies. It was a licensee did it. And that one step of doing it was $150,000. Now they paid for it, paid the bills, which is good. But just that one step of nationalizing, not all the prosecution and everything, just that step of doing it and going all those countries was $150K in cost. So foreign filings are expensive. So searching is a big thing. There are different tools you can use. Obviously, the Patent Office, the World Intellectual Property Office, that's all those PCT applications on the WIPO site, Google Patents. If anyone's curious about prior art searching, I'd be happy to talk about that. I hold a whole other talk about how to do that efficiently. And you can do a lot of work yourself before you hire an attorney to understand what you think your claims are and what the prior art looks like. And then when you work with the attorney, you can ask them very specific questions about the patentability opinion as opposed to a general question. And that can save you time and money. Those are trademarks. All right, I'm going to talk about copyright. It's 1:48. I have 4 slides left, 2 on copyright, 2 on trademarks. Okay? And then hopefully there'll be questions. Copyrights, I talked about a little bit in the beginning. It's an expression of an idea. You do have this exclusive right, but it's a copyright, right? It prevents people from copying your work. It doesn't prevent people from using your work. They just can't copy it over and over again. So and copying comes in different forms. Singing a song is performing the work, right? It's copying it. But obviously, if you're singing it at your house in the shower, you're probably not going to do infringement. Although, I don't know if you remember this from 4 or 5 years ago, these companies started out where they would go around to local coffee shops and actually with small recorders and record people playing Bob Dylan songs and Beatles songs and things like this, and then send them notices and say, hey, little band, little person that just collected $1,000 at the coffee shop, you pay me $2,000 or I'm going to file a suit against you. And they were stuck. And lots of little people, because these companies aggregated these things, and we just send people out to bars to do this, and it became a whole racket around collecting money from people. That's not the best use of the copyright system. But it does last a long time. Your life plus 70 years, right? So if you do a copyright license and the party you're working with really needs to use that software, hey, that's a pretty good deal. You're going to get paid for a long time, so long as it's a fundamental piece of work that needs to be carried on and on again. Or, you know, rest his soul, Prince just passed away a little while ago, and what's in the newspaper, but what his estate's going to be worth over time. And they were giving examples of Michael Jackson's estate being worth billions of dollars, and his name and his likeness and all those songs. So copyrights can be very valuable. But it is possible to work around those. I'll talk in the software context because I would think that would apply to a lot of you. You know, you could have a piece of software, 1,000 lines of code. If someone changes one line of code, is it the same thing? Not exactly the same thing, but it's a derivative. There's a thing called Theseus' paradox. Theseus pulls his boat up on the shore. You take all the pieces of wood off the boat. You walk 10 feet down the shore. You put all the pieces of wood back together. Is it the same boat, right? Or your car. You got a brand new car. You got to change the rear view mirror. Someone changes that one part. Is it the same car? Well, most people would say yes. But just like the word on, as you start to change more and more parts on that car, eventually it becomes a new car. And somewhere in there it changes, right? And that's the whole theory of derivative works. And there's also a big problem with joint works. So the medical doctor with the new healthcare IT idea and the software coder codes it, right? Well, who's the author? The person coded 100% of the code, but it was that medical doctor who was given the instruction saying how to code this up. So they're kind of a contributor to that work. They're a joint author. They're not it's a joint work as opposed to a co-authorship. So you can put the copyright notes to little c if you want to. You're not obligated to do it nowadays, but you can do that. If you want to actually register it, that's when you can sue other people, and it's relatively cheap to do that. You don't have to put all lines of your code. You can just put some portions of your code to be able to do that. You can redact some trade secrets that's in there. Trademark, different thing, Nike swoosh. It's supposed to, again, eliminate confusion in the marketplace. So you know which products are from which companies. It could be names, sounds, words, phrases, logos, whatnot. You need to have distinctiveness. You can't be similar to something else. And there's different categories of distinctiveness, so arbitrary and fanciful. So the word Exxon doesn't really have any special meaning, right? It's kind of arbitrary, but they trademark it's theirs. Suggestive, copper tone, you know, you're going to get a tone, a copper tone on your body. Descriptive, like All Brand or Vision Center. And then there are generic names, like there are names like Kleenex and Frisbee and Thermos. And those can become generic if you don't constantly enforce your trademark, right? So if you're not letting people know that this is my mark, Thermos became generic. Frisbee almost did, and then people got it back, and then they brought the trademark kind of back to life. Kleenex, they hold on to pretty well. And the formatting needs to be pretty specific. If you're going to do my coffee mug, when I was thinking about this talk the other day, I don't drink coffee, it was tea in there. But it was from Life is Good, right? And it had the expression good karma. And they had the TM next to it, right? It's like, wait a second, you can't, that's against all karma rules. You can't trademark good karma. But it wasn't the words good karma, it was the font they used and the curve in it and things like that. So it's highly specific. And when you file for that, it's a highly specific way you get it. And you only have protection around that highly specific mode of it, right? So when you have a trademark, you can, from day one, you can put TM or SM. Those are unregistered marks. It means you're notifying the world that I believe this to be a special mark or trademark, but I haven't gone through the process of registering yet. It's a little bit harder to defend, but at least it puts some notice to the world that you intend to view this as your trademark. Doesn't cost you anything either, right? Well, except for going TM. And TM, SM, so trademark, service mark. It's similar, just in what you provide. Now, when you register it, you'll see the R with the circle. That's when you've gone through the formal registration process. And it's easier to defend because you can put people on notice. And of course, you know, a value of a trademark, a lot of times people come up with names for things. They're not really valuable until people associate that name with that product or that service, and that builds up over years of time. So, you know, when you have a name at the beginning, it could be worth something, but only if you spend lots of time to build up that value, right? Who owns it? Well, you own it unless you agree to assign it to somebody else through your employment or whatnot. No brand is no value. Okay, obtaining it, it's a bit of a process, but it's not too much. You have to demonstrate some sort of use in commerce. So if you want to get a federal trademark, you've got to show interstate commerce. So we actually did trademark Tech, Drugs, and Rock and Roll, that conference name we have. We went through that process. In order to go for a federal trademark, we had to show that people who attended the conference were from outside the state of Massachusetts, and that we had to establish that it was worthy of a federal trademark. You could get a local one, like if you're a coffee shop around here and you want to be, you know, Coffee Break Cafe, and just around the, you know, Boston metropolitan area, you can get a local one as well. You have to do this search. In the search, you know, you get into these categories. So like if you make sneakers and you do a swoosh on sneakers, well, someone else could do a swoosh on, you know, machines that make golf balls. And those two markets are not going to compete with each other. So, you know, the trademark could be used in different markets. You do pay a fee. And the fee depends upon how many classes you want for your trademark. So if you want your trademark just on sneakers, you pay one class. But if you want your trademark to be on sneakers and bags and all these other kind of things and apparel, you'd pay for each mark. So it's like $300, $375 per class. And then depending on how many classes you do would be your fee. It's reviewed by the patent office. Similar to a patent thing, there's sort of a volley back and forth of objections. It gets approved. You pay some fees. It needs to be maintained. So in the 5th year and every 10th anniversary, you have to file this paperwork to show that your trademark is still in use. You're still using it. And if you're not using it, you're subject to this dilution or this genericism. If it can go away. There is a way to file a waiver with them if you're specifically not using it for a period of time, but you want to hold it because you plan on using it. All right, I talked for an hour. Well, not quite an hour, actually. Yeah, and now I'll ask questions. I'll answer questions. I'll answer questions as people want to see fit. Did any come across Lean or online? No. Good, I'm so thorough that I answered all the questions. All right, oh, please, yeah.
So for patents, could you describe the thinking process for when you go about publishing or trying to get peer-reviewed literature published?
You mean before I patent or after I patent?
No, after you patent. At what point in time do you seek peer review?
Sure.
And from your point of view, if you were looking at patents and a patent were not peer reviewed, like at what point in time would you think, well, that's a little bit odd?
Sure, okay, so you're talking to me in a university context, right? So publishing is paramount. So we're usually struggling to file the patent just before that first publication, you know what I mean? So we're in a scramble a lot of times to say, oh, you're going to publish tomorrow? All right, let's get something together. Whereas in a company, you have a little bit more of a luxury because you're not under that pressure. Publishing is not the primary focus of the company, so you have time is a little bit within your control. So I think there's a couple factors at play when I get to the root of your question. If I file my patent today, let's say I got the idea today and I file my patent today, I'm rushing to get an early priority date. Why? Because the law now says it's the first inventor to file, right? So in the US, if I've got an early filing date, if someone else also had the idea, it's a big world, other people have the idea. If I've got that priority date and someone else files a patent, mine has priority, so I'll get those claims, whereas the other party won't because I'm first to file, okay? So there's some pressure to file early, but you want to perfect your idea and you want this 20-year life, right? If I file today, the clock starts ticking on the 20 years. If I file in 10 years from now, I've got these 10 years I kept it a secret plus the 20 years after I filed it, so long as no one else filed it and tried to claim the same thing. So therein lies the strategic discussion about when do I file? Do I file early to get an early priority date, or do I delay it as long as I can to get as long a patent life as I can? And the risk that you run is that a competitor is going to file before you, okay? And this ties into publication because once I file, it publishes 18 months after I file. Unless you file in the US only, you can ask them not to publish it until it issues. But you have to go through a specific request. But in general, they all publish 18 months after you file. But if it's some thing you're trying to keep secret within the company, you can have it not published until it issues, which could be 3 years later, okay? But US only. Overseas, it publishes 18 months no matter what.
Yeah, I guess and I'm not talking so much about keeping it secret. I mean, it came out more recently with Theranos, or
yeah.
That raised millions and millions of dollars and is now under a lot of scrutiny. But I know a lot of the VCs, the Silicon Valley VCs, were put off and weren't among the early investors or investors at all because they found it odd that there was no peer review.
Okay. So
for their patent.
Okay. So this is a kind of a slightly different question. It's really not about the patents. Yeah, it's really not about the patents, but about the technology itself and the validation. So I think the feeling in the marketplace, I was answering the patent question, not the validation of the technology. I think the feeling in the marketplace for the most part is that work done at universities is good work, but usually the amount of experimentation is limited to a smaller set of experiments because you're proving a hypothesis. Once you prove the hypothesis, you don't go on to make the technology robust. And robustness is an important thing for industry. The technology has to work and be repeatable under all sorts of different circumstances. So Whereas you might get the individual experiment in the lab that proves a concept, you didn't do those 10,000 hours in a salt bath to know that it's robust in all conditions, right? Or test it under all the permutations. So yeah, I think the number one thing a company should do when they inherit a technology or absorb one from a university, from a small company, is they should invest some time to validate it and reproduce it inside and get the know-how inside to validate that technology. And that's probably the criticism. Yes, there was lots of this work that showed the concepts were true, but when you actually translate those concepts and put them into work, a lot of things, a lot of bugs can come up in the process when you try to put it into a robust environment. And that's where you need to validate the technology. So that's more around technology validation, where you are on that risk-reward curve. You know, the more it's validated, the more valuable the technology, the earlier it isn't. So yeah, you want to validate the technology as best you can. Universities, it's tough for us to do because our funding doesn't really allow for that. Sometimes we can, sometimes we do. Yeah.
What can you do when you're putting your patent together to help avoid any future hassles from non-practicing entities?
Okay. So the university, by strict definition, is a non-practicing entity as well, right? Because we're a company that makes patents, and we don't use them. We do our research. Well, occasionally we might use some of our patents, but for the most part, we license it to other parties to develop products. So this kind of gets to what we'd say patent strategy, right? And it's going to depend a lot upon your market, your products, the type of technologies you have to develop a full filing strategy, right? Let's say you've got the one patent that's that broad concept like fishing, right? And then you might want to file lots of fence patents, fishing with a fish pole, you know, whatever the different variants are to kind of build up this enterprise or this thicket. Sometimes you use a thicket of all these patents, right? If they're meaningful and if you have 20 patents or something in that field, you've developed this thicket which gives you a little bit of leverage in the marketplace, okay? But that leverage is only good when you have a competitor. And this is the root of your question, right? If you have a competitor who needs some of those patents because they're in the marketplace and practicing, you can use that to kind of horse trade in the marketplace, which gives you some leverage. Now your concern is, I'm giving some background so that people understand. Now your concern is you have a non-practicing entity that has that one patent, and it restricts you from freedom to operate in, let's say the claim is valid, okay? And you're infringing that claim in this scenario. Yeah, you're gonna have to deal with them. So probably the only way you can deal with that effectively is as part of your patent strategy, you're also looking at the freedom to operate. And you're doing a landscape analysis to say, what other patents might I need in order to practice this product, okay? Or if those are the patents that I don't have access to, how could I design my product such that I work around those patents and don't infringe those claims? I think that's your best strategy, is to do that analysis up front and try to direct your products to what your customer needs, but also through that patent maze. Freedom to operate searches, though, can be very expensive. Now, depending upon your field you're in, with some good prior art searching, you can get the 90-10 rule. In a small amount of time, you can get 90% of the references that you might be concerned about. But the world's a big place, right? And it's hard to uncover everything, and word searches are sometimes difficult. But I think if you hired a law firm to do a really detailed, like sign on the dotted line, freedom to operate search, you might spend $100,000, right? And that's beyond the budget of a lot of people. But you could spend a lot of your own time doing it for free, and then maybe hire a firm to do something for $10,000 or $20,000 that maybe takes what you did, and maybe they answer some specific questions, or maybe they look at the references that you brought back to talk about how you might work around a claim, or how you might devise your strategy. Or maybe you just have to deal with some of those parties. If they do own a good patent in the marketplace, and that's the gate to get to that marketplace, then it's a bargain, right? It's like, what price does it make sense to me to go into that market and pay them a price, and what doesn't, to get onto that real estate, to drill the well on my property. If I own the well, if I own the rights under the ground, I've got some leverage, right? And then there's a certain price that I won't pay to drill my well. Did I answer your question? I mean, I believe in the strength of intellectual property. So I don't really believe in I'm glad you didn't use the word patent troll or something like that, because the patent rights help the small guy, the small company. If the patent system didn't exist, the small guy wouldn't have a chance. And it's important to be able to have people who can enforce these rights for you, because a lot of times the small guy doesn't have the resources to be able to enforce those rights. So a lot of the non-practicing entities operate in a very straightforward, above board, proper way of doing things, where they're really just trying to help the small guy, right? But other ones, you know, there's all different players in the world, and other ones are probably a little less, have a little less integrity, perhaps, you know. Are there any online questions? All right. Well, I guess if there are no other questions, I can stop talking. All right? All right. Thank you for your time. Oh, do you have to say a closing? Oh, sure.
Thank you, everyone, for attending online and in person. The slides will be available online. Also, the live stream video will be online in a week and a half or so. Thank you again on behalf of CFTCC.